one day, and my client is a little bit older than me, and he had a young lady with him, and if he'd have said, "This is my daughter, Ray, I'd like you to meet her," I'd have said, "Hey, how you doing?" But instead he said, "Ray, this is my fiance," and I went, "Hey." And so he said, "We're here for a prenup." Okay, so what's a prenup? And what does it do? More importantly, what does it do?
Separate property, money, different things.
It distinguishes the difference between community property that you would otherwise roll into after you're married from separate property. So I said, okay, great. So I walk back to my office and I'm typing it up, and he rolls down the hallway into my office because he knows where I'm at, and knocks on the door. He goes, Mr. Ray, I know what you're thinking. I saw the look on your face. He said, it's not like that. It's not like that. He goes, we met in church. The Lord brought us together. And I said, I'm not judging you. I'm judging you, but I'm not judging you. So we finished the marriage contract. I go back into the conference room and I bring in Mom and someone else to be the witness, and we witness the document. And as we're walking out and they're leaving, I said, Mom, I don't think this thing is going to make it 6 months. And she says, Ray, it's not going to make it 6 weeks. And she was right. It rolled closer to the 6-week mark than the 6-month mark. So my client works offshore. I get a phone call from him one day. And he says, oh, Mr. Ray, she up and did it to me. And I said, what happened? He goes, I came home from work and all my furniture's gone, my checking account's closed, and she stole my car. And I said, oh man, I'm sorry. Not surprised, I'm sorry. And I said, I don't know what to tell you. He says, well, thank goodness I got that prenup. And I said, oh yeah, it's going to help you a lot. You were married for 6 weeks. I'm not really sure what it's going to do for you. He says, well, what's my next step? And I said, well, you know, you've been married 3 other times. I would imagine you can give me a tip or two about what the next step is. I said, you got to get a divorce. He says, but I had a prenup. And I said, that's right. As far as a prenup is concerned, you have no property issues. You stated prior to getting married that whatever was yours would stay yours, whatever was hers would stay hers. You've not had any community property issues, so you still have to get divorced, but you don't have to partition your property. He says, well, speaking of property, she stole my car. She took my car and I want it back. And I said, you might be involving the police here. I said, you might be teetering into a criminal issue. You might want to file a complaint with the police. He says, okay. So we hang up the phone. A little while later, I get a message on my voicemail. Mr. Ray, would you please call Officer so-and-so at the St. Annie Parish Sheriff's Department? You speak so good and I don't speak so good. I can't seem to make him understand the difference between community property and separate property. And of course, my head goes, so of course, I can call a policeman and teach him a few things about community property and separate property. That's what I do. So I pick up the phone and I call the officer, and unfortunately I get him on the phone right away. It doesn't give me a chance to think about it. I said, oh, Officer so-and-so, I'm Mr. Client's attorney. I said, I understand y'all had a breakdown of communication as far as community property and separate property is concerned. I wanted to kind of give you a little overview of the two. You know, Louisiana's community property state, and there's this presumption of community, and I must go on for 15 minutes, and it's beautiful. I mean, it's good stuff. And so at the end, there's a pause, and I'm expecting him to say, thank you, counselor, you've cracked the case. But instead he says, thank you, counselor, but I knew the difference between community property and separate property even before you called. He goes, do you know the difference between ownership and possession? And I said, oh no. He says, you see, by your client's own admission, his wife, even when she was his girlfriend, has had keys to this car, could take it freely, come and go as she pleased, never had to ask for permission, never had to tell him where she was going. So your client just can't wake up one day and decide that his girlfriend or his wife has stolen the car. He's got to let her know that he wants the car back. He's got to give her a reasonable amount of time in which to return it. And only at that point in time, if she doesn't return it, then can he call and talk to me about it. But until then, no, I'm not going to do anything about it. So, counselor, do you know the difference between ownership and possession? And I said, thank you, officer, because I would never be able to make up a story this good. So, that's the difference between ownership and possession. Ownership and possession on page 84 says, ownership is the right to confers on another person direct, immediate, and exclusive authority over a thing. Possession is the detention or enjoyment of a corporeal thing. Someone who has ownership of a thing has the right to possess it. My client had the right to possess his vehicle. It was his vehicle. But he allowed someone the detention or enjoyment of that corporeal thing, had failed to revoke it in a reasonable time frame. That was the breakdown.
So was it going on, I mean, prescription, or, I mean, because there was no lease, there was no, even as a
They would have to
girlfriend.
put her on notice.
Yeah, he needs to send her a text, he needs to get her a voicemail, something that he'd be able to go to the policeman and say, look, 2 weeks ago, here's a text, here's a reply to my text saying I wanted my car back, and it's been 2 weeks and she still hasn't returned my car. At that point in time, I think that the police will get involved. But he's going to have to demonstrate he's made some effort to put her on notice he wants the car back. And look, there's a reasonable person standard. If she's moved out of the house and closed his checking account and taken all of his furniture, then it's reasonable to believe he would want his car back. So I think that the policeman is going to not make him wait a month or 2 months or 3 months. Prescription does run in situations where you take someone else's property, even in bad faith, but in this particular situation, it had only been a day or two because he works offshore. So even if she had taken it 2 weeks before, he would have had no knowledge it was gone until the day he got back, and that's when the clock would have started ticking. And I think she has to hold on to it for 3 years before she'd be able to claim it's hers under a prescription theory. Even a bad faith prescription theory, I think, is still 3 years for movables.
I like that story.
That's one of my favorites. That's one of my favorites. So
Very true, too.
it is unfortunately very true.
And you, as much as you try to hold your face.
Oh yeah. When he said, do you know the difference between ownership and possession? I just dropped my head.
You feel
so-
like this big.
I am so stupid. All right, it says ownership is the right that confers on a person. I think we just read that. All right, so the paragraph afterwards says, before a constitutional amendment in 2004, a buyer and an occupant of residence under a bond for deed contract was considered the owner of the thing for homestead exemption purposes. However, effective December 7th, 2004, no bond for deed property is eligible for homestead exemption, except that any homestead exemption granted before June 20th, 2003 on any property occupied on December 7, 2004 by a buyer under a bond for deed contract remains valid as long as the circumstances giving rise to the exemption at the time of the exemption was granted remain applicable. That's a mouthful. So to break that down, what's a bond for deed? A bond for deed is a promise to deliver title at some point in the future. It's an installment contract. So if I go to Jessica and I want to buy your house and you want to sell me your house and circumstances warrant where you want to sell it to me and I want to buy it from you, but I can't go to a bank and borrow the money. And we decide we're going to come to an arrangement where I'm going to pay you over time. A bond for deed is a method by which I do not take ownership of the property until I make my final payment to you. When I make my final payment to you and I no longer owe you anything for the house, then you deliver ownership to me. Until that time, I'm kind of a quasi-lessee. This is kind of a hybrid lease arrangement. Now what they're saying is that as far as ownership and possession is concerned, they considered a bond for deed kind of a hybrid. Even though there was no ownership in a bond for deed for the buyer, as long as I owner-occupied the house as my primary residence prior to 2004, I could at least get homestead exemption. And under state law, homestead exemption is a benefit only for homeowners. And so what they're saying here is that in that bond for deed scenario where I'm really a glorified lessee, I still qualify for homestead exemption. But somewhere around 2004, they said that doesn't work. You can't be a lessee and get an ownership benefit, and they took it away. But what they're telling you is that they grandfathered anybody that already had it. They didn't take it away from people that qualify for homestead exemption prior to 2004. They just wouldn't let anybody else have it. And as long as...
They'll snatch it quickly, though.
What's that?
They'll snatch it quickly.
They will. That's what they're saying right here. So if I move out of the house and I lose my homestead exemption and I move back into the house for some reason, I'm not getting it back. So if you lose it, you're not getting it back, and they will take it away pretty quickly. And rarely, because it's been 12 years, rarely do you see that anymore, because bond for deeds typically don't stay in place in perpetuity. A bond for deed is a practical matter. This is not in the book, but a bond for deed is a practical matter, is a short-term ownership tool. Where I come to Jessica and I say, I want to buy your house, but I just started a new job, and my banker says I got to be on the job for 2 years before I can qualify for a loan. And you say, well, I'll owner finance the house for you for 2 years. So bond for deeds don't generally run for 15, 20, 25, 30 years. They're generally short-term, 2 to 5 years, where the purpose, where the circumstances that are preventing me from buying it traditionally change, and I can now come back and buy it from you. Now, that's kind of an odd place to put this, but what they're trying to talk about is the difference between ownership and possession, or the difference between ownership and right to possess, and how there were some hybrid scenarios prior to the law, or prior in the law. All right, Article 479, the right of ownership may exist only in favor of a natural person or a juridical person. The ownership and the possession of a thing are distinct. Ownership exists independently of any exercise of it and may not be lost by non-use. Ownership is lost when acquisitive prescription accrues in favor of an adverse possessor. All right, so that's what Dina was just talking about. She says, hey, when's prescription running against this wife who's taken this man's car? And what they're saying is that that's possible. Now, they don't tell us here what the time frame is, but what they're saying is that if my client never did anything about that car and let her have that car for a certain period of time, actually, that's a bad example because the car is titled. But the furniture, let's talk about the furniture. When my client does nothing to recover that furniture, okay? He knows where she's gone and he knows where his furniture's at. As far as he's concerned, he can get that furniture back anytime because it's his furniture. He went to the store, he bought it, he paid for it. Well, what they're saying is that if she holds on to it long enough, even though she's in bad faith, which is that adverse statement, that adverse suggests that she knows it's not hers, but she's possessing it anyway, at some point in time, that furniture will become hers. At some point in time, it will become hers. The car is a bad example because the car is titled, and ownership only changes with the transfer of the title. That's why the car is a bad example. But the furniture would fall into that category. Cody, were you going to say something? No. Possession is the detention or enjoyment of a corporeal thing, movable or immovable, that one holds or exercises by himself or by another who keeps or exercises in his name. The exercise of a real right, such as a servitude, with the intent to have it as one's own is quasi-possession. The rules governing possession apply by analogy to the quasi-possession of incorporeals. The exercise of real rights of servitude with the intent to have it as one's own is quasi-possession. Okay. Nature of possession, right to possess, 3422. Possession is a matter of fact. Nevertheless, one who has possessed a thing for over a year acquires the right to possess it. So there's the time frame, Dina. If she'd had that furniture for 1 year, she would have had the right to possess it. Under Roman law, ownership could be divided into 3 parts: the usus, the fructus, and abusus. Highlighted. Usufruct is very, very important. Usus is the right to use, experience, skill, advantage, or profit. Fructus means fruit, profit, enjoyment, or produce. Abusus means the right to consume, dispose of, or alienate. Under the Louisiana Civil Code, usufruct essentially comprises usus and fructus. Naked ownership is the bundle of rights formerly called abusus. Since naked ownership eventually ripens into full ownership, the usufruct is considered a burden on ownership. Where do you see that? Where does usufruct come into play?
Especially married when the husband had died.
That's succession. When the husband dies, succession.
You know what, I recently saw it where a mother has, she inherited everything from husband.
Mm-hmm.
Husband had been married before, so he has heirs from first marriage.
Right.
Her daughter is still living, and she gave her daughter usufruct of the house, as long as the daughter's alive.
Okay.
Her, because she owns the house
Outright?
outright, because the will say everything when he died went to her. She changed it, so the daughter has the usufruct. Now, the other siblings are the naked owners,
Mm-hmm.
but she is the use until till her death, or, you know.
All right, so let's talk about that again. So in this particular scenario that you're talking about, husband and wife, husband's got children from a first marriage, wife has children from a first marriage. Husband leaves wife the house, okay? And they must have made a deal during their lifetime that when whoever's the last one of us dies, they're going to leave everything equally to the kids. But wife rolled into a notary's office after husband dies, and she changes her will, and she says, when I die, my daughter gets usufruct of this house, and my other stepchildren get the naked ownership. So that means that my daughter gets to use this house until her death, and the other kids just got to wait.
See, I never heard
Of the what?
offspring having a usufruct.
Oh, you can give usufruct, yeah.
I know.
Yeah.
You know, you just usually think about married couples or couples, yeah.
So that's what happens. That happens an awful lot. And for anybody who has any intentions of drafting wills for people, it's not the husband and wife who've been married once who have the same biological children that you're going to be dealing with issues with. It's always the husband and wife who've got biological children from previous marriages, where they feel as though they want their spouse to have the ability to do everything and not deal with my bratty kids. But by the same token, I don't want my bratty kids to be cut out, and there's no way to make both things happen. Not that I'm aware of, at least. If I give my wife everything, I always run the risk that after I die, she rolls into a notary's office and does exactly what the wife in your example did. You know, there's nothing I can do about it. You know what she could have done? She could have left everything to their daughter and cut the stepkids out entirely. By the same token, if I leave my wife usufruct of my half of the house and I leave my biological children the naked ownership, when my wife wants to sell or refinance the house, she's got to call my kids who hate her because they love their mama and deal with them on those issues. And that's what the dad or the wife's trying to avoid. I don't want my spouse to deal with my kids because they don't like him or her. And so I want her to have everything. Oh, by the way, but I want my kids to get it when she dies.
What if
No
there was a
guarantee.
prenup?
What if there's a prenup?
Well, how would that situation change if there was a prenup?
Well, you got to tell me what the percentage of ownership of the house is.
Say there was no will,
Okay. All
how
right.
would that work?
All right, so there's no will, and there's a prenup. Now, a prenup says that it's not community property, and the community property is what creates the usufruct. And I'll tell you what, let me come back to that example because I want to explain this real. Yes, ma'am.
On the exam a couple of years ago, for the scenario that you had to make the document for, they were selling the house, but the seller son had a usufruct on the property. You can't do that, can you?
Can't sell it subject to the usufruct.
Can you sell it and still have the usufruct for their son?
Well, you can only sell what you own. So in this particular scenario, you're telling me that dad owns a piece of property and he's got the.
He's selling it.
Dad has the abusus,
Yes.
right? And the son has the usus and the fructus.
Yeah.
All right, I can sell my abusus, but that means that whoever buys my property still has to let my son use it. So it can happen. It's not practical. Who wants to buy something that they got to let somebody else's kid use until they die? So it can happen, but it's not a very
Because I left
practical
it up
scenario.
because I thought you couldn't do that.
You can do it. It's,
Yeah.
it's not a practical
That's why I got
situation, but
wrong.
it can. Maybe. All right, so I'm going to come back to your question in just 1 second. So what happens typically is that there's 3 levels of ownership: the usus, the abusus, and the fructus. The naked owner only has one element. They have the abusus. The usufruct has 2 elements. They have the right to use it and the right to the fruits of it. Now typically, the best way to understand how a fruit works would be they have let's say it's a house, and I have the usufruct of the house, but I can't bear to be in the house after my wife passes away because it's just too difficult. So I move out of the house and I rent it. The fructus means I can enjoy the rents associated with that house. And when my lease expires, if I want to move back in, the usus says I can do that too. But what I can't do is I can't sell the house outright to someone else because I don't have the abuses. That's the naked ownership element. Now, usufruct is a natural mechanism of a married couple that dies without a will. So if my wife and I own a home and we own it in community, so it means that we bought it after we were married, and I die or my wife dies, the surviving spouse is going to get usufruct as a mechanism of community property. That means that my children, without a will, are going to inherit my half of the house. My wife is going to already own her half of the house, and she will inherit the usus and the fructus of my half. And my children will inherit the abusus of that house. Okay. Now, so Sanjanita's example is, I'm separate in property, and I have no will. If I'm separate in property, I have no mechanism of community property, therefore usufruct does not kick in. That means that my children will inherit my half of the house, my wife will already own her half of the house, and without the usufruct, they can go sue each other over that house now. If they can't agree on what to do with it, then go sue each other over it, because without the usufruct, my wife can't say, hey, I want to use the house. Or my wife can't say, hey, I want to move out of the house and rent it. She's got to square up with my kids if my kids want their half of the house. Okay, so that's how that example.
They could actually make her pay rent for half of that house.
What's that?
They could actually make her pay rent if she can't move.
Absolutely, they can make her pay rent. And so that kind of leads me to the story about my client. I have a client of mine, a very, very good client of mine, who he and his siblings inherited a half interest in a home that their dad had with their stepmom in Lakeview. And we're talking like a nice $400,000 or $500,000 house. And he inherited it at a time back when Louisiana had forced heirship. And we'll talk about that. But forced heirship is a concept that we still have in part, but it's this idea that you have to leave stuff to your kids. The kids were estranged from their dad. Dad left mom with the kids, ran off with the new wife, and they didn't like dad, they didn't like the new wife, but they still inherited the house. They knew when the mom got married that they'd have to square up, because a usufruct, if it's not given by testament, will terminate at the death or remarriage of the usufructuary, whichever comes first. So either the stepmom dies or she remarries, but either one of those 2 events will trigger the termination of the usufruct allow the children to come into the dad's half of the house, force a sale to get their share. You all with me so far in this example? You are? You okay? All right. So you're hanging in there. So what happens is that the kids are all standing by because the house is worth $400,000. And the kids are all standing by because they know it's paid for free and clear. And the moment the evil witch stepmom remarries, they're going to go sue her and make her give them $200,000. Or they're going to make her sell the house and split the proceeds 50-50. And they're all just chomped a bit. They can't wait. They can't wait. They can't wait. She gets a boyfriend. They get all excited. They can't wait. They can't wait. And she ends up living with this guy for like 15 years. And they just cannot believe they're not married. Cannot believe they're not married. And they're asking their friends, did they get married? Did she change her name? What's going on? They get married? Get married? No. So she dies. And they finally get their half of the house. And they're dealing with the attorney handling the stepmom's succession. She married 15 years before that, never told anybody. Never told anybody. Married, ran off to Las Vegas, got married, had a marriage certificate, was married to this man, were in community property the whole bit, but never let anyone know. And because they got married in Las Vegas, there was no records here in St. It was in Orleans Parish. No records in Orleans Parish. So unless they told someone, my clients really had no way of finding out. And they had no other outward appearance. So she knew that the moment she got married, those kids were going to come after that house. So she kept it a secret until she died. And Jessica said that's awesome.
So what happened?
What happened to his part? I mean, like,
Yeah.
Well, the kids eventually got their half.
They just had to wait.
They just had to wait 15 years more than they had to.
but then he got her half?
What you mean?
The living space? That
was actually
she just
that was
had
actually
Lucifer.
part of the reason why this information kind of came to light, because the husband that she married said, "Don't I get half of this house?" And he didn't, because she had a will leaving it to her biological children. And so that's kind of how it came to pass. Is they're kind of going through the process of trying to sell the house after she dies to get their money. The husband starts claiming, "I got a usufruct over this house," and they're like, "Wait a minute, you don't got a usufruct. You weren't even married to her." "Oh yeah, we were married. Here's a marriage certificate." Had they known that they had gotten married 15 years before, the usufruct would have been terminated, and they could have sued her and forced her the sale of the house 15 years prior and gotten all their money many years ago.
So did his
Slick.
kids and her kids had to split it?
No, the husband that she married on the slick really had no rights to anything. Because if my wife owns property before we get married, it stays her property, even without a marriage contract. What you bring to your marriage, there's this presumption that when you get married, everything that you've got then belongs to him and everything he's got then belongs to you. That's not true. A marriage contract just says anything that we acquire after we get married stays our separate property. We don't get a contract that says what I bring to the marriage stays mine. So the house was hers from the husband of my client.
Right.
Or the house was hers from the father of my client. When she remarries this guy on the slick, that house never becomes his. It's never his property. He never gets a usufruct despite the fact he's married.
Right.
It would have had to have had an interest. It would have had to have been their community asset for the usufruct to kick in. So he never had an interest in anything, but he was trying to raise the issue he was entitled to the house while they were trying to sell it, simply because he didn't want to move out. It was a free place to stay.
But if she would have done a donation
Of what?
of the house, like the property, then would he have gotten?
Okay, so that's a good question, Shayla. So what Shayla's saying, why not have the wife go ahead and come clean and say that they're married, and then donate a half interest in the house? She only had a half interest in the house, which means that she would have owned a quarter, new husband would have owned a quarter, the estate of the deceased dad and all of my client's siblings would have owned a half. And now that she's outwardly married, the usufruct terminates, and my clients can force a sale of the house. Yeah, Dina? No?
Okay, so why wouldn't she have owned, okay, there were 4 stairs?
My clients were forced heirs.
Okay, then why wouldn't she have owned half the half?
Owned half of the half. They inherited half of the house. I know what you're saying. You're saying that under the forced heirship that he could have left her the non-disposable portion of the estate. He could have left her a quarter of the house, so that she would have had 3/4, and he would have had, my clients would have had to split 1/4. It just didn't work out that way. I don't think there was a will, so they inherited his half. They inherited his half. But because it was a community asset, they inherited his half, subject to her usufruct over their half. And that's why they needed her to get remarried or die to be able to get into that house. And she lived 15 years married on the slick, and they had to wait 15 years to get their half of the house. Robin said, who do that?
I said, how do you do that?
You run off to Las Vegas, you get married in the chapel,
Yeah,
you
yeah.
come back, and you tell no one. You tell absolutely no one that you've done it.
My husband
What
told
about
me 40 years ago, if I tried this scenario like he's talking about, because of our age difference, he would haunt me every night.
All right,
What about like on tax returns and stuff, if you're married?
sure. Tax returns aren't public record.
You can file
You know,
separate but married.
Oh, that's true.
I mean, you got to keep in mind that my clients don't get along with the stepmom, and the stepmom knows that they're itching for her to get remarried so they can come do this. So it's not like she made any effort to let this information get known. They could have filed joint tax returns. There may have been some reason. There may have been some marital benefits, but unless they're public record benefits, my clients would have never had access to the information.
Okay.
All right?
Wow.
Wow.
Elaine will be saying that.
Okay, so where were we at?
It's so
Yes.
Ownership may also be subject to a resolutory condition, such as a sale with a right of redemption. I talked about resolutory conditions 1 or 2 meetings ago. Does anybody remember what a resolutory condition is?
No.
A resolutory condition? What's that? That's right. That's right. That was the example I'm going to start using. Resolutory condition is an event that in the event that something happens, it undoes the nature of our contract. And the example that Mom used that everybody loves is the military person that's in a lease that gets
Yeah.
deployed.
Yeah.
Because of the deployment, the military person has the ability to get out of the lease.
Right.
And so that's a resolutory condition. It's something that says if an event takes place, it changes the nature of our contract. Okay? I think I've got a good example of resolutory conditions too, but. All right, so it says ownership.
That was just easier to remember.
I have to admit that's true. It is easier to remember. Ownership may be vested in one or more persons. Where it is a single thing that it is owned by more than one person, each has an undivided share in the thing. It is said to be owned in division. So if Jessica C. and I buy a piece of investment property together, and we go to the closing, and we don't specify that she owns 75% and I own 25%. It's just Jessica C. and then it's me. There's a presumption that we each own 50% of the property because no other indication as to our ownership percentages have been specified. Now, amongst us, we might know that you own 75% and I own 25%, but to all third parties who see that document, there'll be a presumption that we owe it in equal proportions. So when we do a closing and multiple people are buying property, we tell them there is going to be a natural presumption that you own an equal share unless you tell us what the shares are. More often than not, it's equal shares anyway. A possessor is considered provisionally as an owner of the thing he possesses until the right of the true owner is established. In order to become a possessor, a person must intend to possess as owner and must take corporeal possession of the thing. When a person exercises a real right that is incorporeal, such as a servitude, he is said to have quasi-possession. My client's wife who took his furniture, she was a possessor. She took that furniture with an intent to possess. It says where the real right is incorporeal, like such as a servitude, I can't actually possess that servitude because that servitude's incorporeal. If I choose to use it, okay, I'm using that servitude to access a piece of property, I'm a quasi-possessor. I don't actually have it in my possession, but I'm using it with the intentions to possess. Does that make sense? Accession. Accession, generally speaking, is the addition to or increase in value of property by means of improvements or natural growth. Unless other persons have rights to them, accession grants to the owner a thing's natural and civil fruits. In relation to immovables, it also includes the right to everything above and below it, as well as in additions to it. Accession sometimes happens with real estate, with land, where a waterway would sweep land onto your property, like the inclusion of land over time. That's an example of accession. Now, it doesn't happen overnight, but if a waterway comes a certain way, eventually it might actually increase the land. More often than not, what you see, what's it called? Is it called the opposite? The opposite is where it takes it away. Dereliction. The opposite is where the waterway actually takes your land away. And when your land gets taken away, it's not like it's yours wherever it goes. What's left is yours. Okay?
Make my name's on that grand.
Ownerships of fruits by accession, the absence of rights of other persons. The owner of a thing acquires the ownership of its natural and civil fruits. So if I have a house, I'm entitled to collect the rents. Accessions above and below the surface, unless otherwise provided by law, the ownership of a tract of land carries with it the ownership of everything that is directly above or under it. Alluvion and dereliction.
There we go.
There we go. Accretion forms successfully and imperceptibly on the banks of a river or stream, whether navigable or not, is called alluvion. The alluvion belongs to the owner of the bank, who is bound to leave public that portion of the bank which is required for the public use. The same rules apply to dereliction formed by water receding imperceptibly from a bank or a river stream. The owner of the land situated at the edge of the bank, left dry, owns the dereliction. So let me see if I can come up with a better example of a cession than that then. Is a cession, would that be like the example of a cow that produces a calf? That you're entitled to the calf? I'll come back on Tuesday with a better example of a cession. Ownership of fruits. 86. Fruits are divided into natural and civil. Natural fruits are the products of the earth or of animals. Hence, natural fruits would include fruit from trees, eggs, milk, and wool. Civil fruits are revenues derived from a thing by operation of law or by reason of a juridical act, such as rentals, interest in certain corporate distributions. Kinds of fruits are important, guys. Kinds of fruits are important. A cession in relation to immovables is mentioned above. All things below and above a corporeal immovable belong to the owner of the immovable. These include buildings, unharvested crops, ungathered fruits, and uncut timber. However, they can be owned by another. Where the building, crops, timber, and fruit-bearing plants are placed, there with the consent of the owner, a cession may be avoided if ownership of these things is evidenced by a written act and filed for registry in the conveyance records of the parish where the immovable to which they are attached is located. However, where they are made without the consent of the owner, a cession cannot be defeated, and ownership of them belongs to the owner of the immovable to which they are attached. All right, as mentioned above, all things below and above a corporeal immovable belong to the owner of the immovable unless the law provides otherwise. Where buildings permanently attached, constructions, and plantings are placed there with the consent of the owner, the person who put them there owns them. However, when they are made without the consent of the owner, a cession cannot be defeated, and they belong to the owner of the immovable to which they are attached. Article 493 and 491 provides that the landowner is presumed to own buildings, other permanently attached constructions, standing timber, and unharvested crops or ungathered fruits of trees, unless an instrument showing separate ownership is recorded in the parish conveyance records. All right, let's flip it over to page 88. And let's take a look at let's look at the first big paragraph at the top of page 88. It says where a corporeal movable is incorporated into an immovable, it is called a component part. Component parts ordinarily belong to the owner of the immovable. Where made with the consent of the owner by another, they can be removed by a person incorporating them by restoring the immovable to its former condition. We've already kind of touched on that. That's the example of a dentist office who's got all the stuff affixed to the walls and to the ceiling. They can still be declared the property of the dentist as movables to be recovered by the bank as long as they can restore the property to the condition it was in before they were attached. A cession in relation to movables, the next big paragraph at the bottom of page 88, it says a cession can also occur in relation to movables. For example, if someone owns a car, he will likewise own the key that starts it. Movables are divided into principal and accessory things. An accessory thing is a corporeal movable that serves the use, ornament, or complement of the principal thing. That's a test question. Hasn't that been on the test before? The idea that a person can buy a car and not the key, that kind of stuff. So you've got to realize that that's something that has been tested. Transfer of ownership on page 89. Ownership is acquired by succession, either by testate or intestate. What's a testate succession?
With a will.
With a will.
And intestate is without a will. I said by the effect or obligations or contracts and by operation of law, the concepts that are discussed in the chapter on sales, donations, and successions, which we'll cover later. Protection of ownership. The rights of a possessor are subordinate to the rights of the owner. Where the owner does not exercise possession over a thing, he may recover possession from the person who has it. That's my story. That's that story right there. My client, who owned the car and the furniture, has the right to recover those things from the wife who possesses them, or the soon-to-be ex-wife who possesses them. As in regards movables, the possessor is presumed to be the owner. This is Louisiana's version of possession is 9/10 of the law. That's not something we actually use here, but we hear it all the time. You hear possession is 9/10 of the law. It's on every TV show you ever hear. That's not really a civilian concept. I actually did some research on this at one time. It's not even a common law concept. It's actually a medieval European legal concept that has kind of been translated into common law and civil law over the years. The possessor of Article 530, the possessor of a corporeal movable is presumed to be its owner. The previous possessor of a corporeal movable is presumed to have been its owner during the period of his possession. These presumptions do not avail against a previous possessor who was dispossessed as a result of loss or theft. A person who claims ownership of an immovable against someone else possessing it must prove that he has acquired ownership from a previous owner or by his acquisitive prescription. That's why if you sell someone a car, they want to bill a sale. They want some sort of documentation that says they didn't steal this car from you. Acquisitive prescription, top of page 90. Acquisitive prescription is a mode of acquiring ownership or other real rights by possession for a certain period of time. The common law concept is statute of limitations. We call it acquisitive prescription. It says in the second paragraph in our acquisitive prescription is interrupted when possession is lost. Where the person recovers possession within 1 year, interruption is considered never to have happened. I had a client of mine who had fenced in a piece of property and she had possessed it for a very, very long time. And she went to go file a suit to quiet title. And this was not that terribly long ago. And the people that she was trying to take the property of argued that she had lost possession and didn't regain it within a year. And what had happened was Hurricane Katrina had blown down the fence. Actually, it had blown down some trees that had knocked down the fence. And she didn't get the fence back up right away. And they were able to prove by affidavit and by testimony of neighbors that the fence was down for more than a year. And therefore she lost possession, and her prescription interruption was going to prevent her from prevailing in that suit. So where you maintain possession with the fence, you've got to keep that fence up. And if that fence comes down and you don't get that fence back up within a year, you've lost that time. Now there's this idea that you've got to have outward possession. We may not cover it here, but we will cover it. I got a client of mine that had a piece of property, and I told him this wasn't going to work, and to my knowledge he made no effort to do anything about it. But he said that when his grandfather bought the property next door, and his grandfather went out and planted all these bushes in this nice big area around the property. And it's perfectly clear that he intended to possess the property on the other side of the bushes. And if you look, it's beautifully manicured. I mean, it's clear that someone made an effort to plant these bushes in this manner. I did a little research. There's no case law that indicates that you can hold possession with shrubbery. You know, possession generally requires fencing, something outward and adverse. Who's to say that you know, people who just drove by and saw those bushes didn't just think it was a fluke that they grew like that? So I told them it wasn't going to work, that you can't have possession simply by planting something as a barrier between you and someone else. Alright, so it says in the bottom of page 90, in order for acquisitive prescription of 10 years of immovable property. Now I'm at the below Article 3486. It says in order for acquisitive prescription of 10 years of immovable property to be effective, a person must have possession for 10 years, good faith, and just title. That's important. That's very important. Without those three elements, you cannot get 10-year acquisitive prescription. The idea squatters' rights, that term squatters' rights, is typically associated with bad faith possession. Just the term squatter in itself gives you some indication that the person that's on your property knows it's not their property. So in order for squatters' rights to take place, you have to have possession for 30 years. Your good faith status and whether or not you've got documentation that says that you own the property is not relevant. If you've got 30 years under your belt, you can make a move for 30-year acquisitive prescription or the traditional squatters' rights. But in order to have 10-year prescription, I got to have a document that says I own the property, and I have to be in good faith. I have to know or believe that the property's mine. And it becomes kind of gray if somewhere in the middle of that 10 years I find out that it's not my property. Am I still in good faith because I was in good faith on the day that I bought it? I don't know that there's a real clear answer on that. But any example that you give on the test, you can almost guarantee, I can almost guarantee you that it's going to involve two of these three things. Okay? Or it's going to involve two of these things in a very liberal interpretation of the third one. And they're going to want to know, do you realize you need all three elements for 10 years? That's how I think I would test that question if I was going to test you on it. Just title is a juridical act in the bottom of page 90, such as a sale, exchange, or donation sufficient to transfer ownership. The act must be written, valid as to form, and filed for registry and conveyance records of the parish in which the immovable is situated. So if you've got something that's on a piece of paper and it's been drawn on with crayon and it's never been recorded, but it says you own this property, you can't be in good faith and rely upon that as just title. It doesn't meet the elements of what a title transfer should be. So the title transfer has to be valid. The underlying ownership in the property isn't going to be, but the title transfer itself has to appear to be valid. Be valid as to form, valid as to procedure. That make sense? Acquisitive prescription of movables on the top of page 91. Ownership and other real rights in movables may be acquired either by acquisitive prescription of 3 years or 10 years. Where a person has possessed a movable as owner in good faith under an act sufficient to transfer ownership and without interruption for 3 years, he acquires ownership of the movable. Where a person has possessed a movable as owner but lacks good faith or title transferring ownership, he must possess the movable for 10 years in order to acquire ownership of the acquisitive prescription. In my example of the lady who took my client's furniture and car, which one applies to which?
She wasn't a mistake. Lack of good faith.
Okay, so which one applies? As it pertains to the furniture, how long does she have to have it?
10 years.
10 years.
Okay, when it pertains to the car, how long does she have to have it?
10 years.
10 years. Now, I'm not sure how she'd ever transfer title because, I don't know how she'd ever transfer title to that car. But I guess after 10 years, that car's probably not worth a whole lot anyway. Because the DMV is not going to recognize 10 years of possession as a basis for transferring title. She'd probably have to file a suit and get a court order to be recognized judicially as the owner before the DMV would recognize it. Ownership in indivision is a term you need to become familiar with. It's a term we're going to use throughout the entire book. It says where a thing is owned by more than one person, it is called ownership in indivision. Where a thing produces civil or natural fruits, co-owners share in the fruits in the same proportion as their ownership, which is presumed to be equal in absence of a juridical act or other provision. So in the Jessica C. example that I gave where we co-own a piece of property, and I said we don't stipulate that she owns 75 and I own 25, it's presumed that we own 50-50. And if we put a tenant in that property and that tenant pays the rent, it's presumed that I get half the rents and she gets half the rents. So if we don't have a juridical act that indicates a different percentage, that's going to be the presumption. That's what everybody's going to rely upon. All right, each owner, I'm skipping over 797 and 798, it says each owner is entitled to use the thing held in division according to its intended purpose, except where provided to the contrary by the agreement of all the co-owners. However, he cannot, by using the thing, prevent another co-owner from also using it. All right, so we'll go to page 92 and look at the bottom 2 paragraphs. It says the mode of partition may be either extrajudicial or, if the parties cannot agree, judicial. Extrajudicial partitions are done by juridical act. The parties can divide the property, they can sell it and divide the proceeds. What they're talking about right there is what happens if Jessica C. and I eventually can't agree on what to do with the property. So in the example, we bought this house and we're renting it out, and all of a sudden one day I decide that I want to live in the house myself, and she says, no, I want to continue to rent it, and we just can't agree on what to do with it. We can split the property if that's an option. If splitting the property is an option, that's great. Maybe it's a duplex and I can take one half and you can take the other. But if it's not something that can be split by a juridical act, we can't agree to split it by juridical act, and we can't agree on what to do with it, we're going to sue each other over that. And that's what they call the extrajudicial process. That's where it's going to be, that's what they call the judicial process, where we end up suing each other. Extrajudicial is where we end up agreeing by contract. The very last paragraph on 92 says, judicial partitions are either in kind or by licitation. That's an example of a judicial sale. If the property can be divided in shares closely approximating each co-owner's percentage ownership without much of loss of total value, the court shall order partition in kind. But you can't partition in kind a single-family home. You can't cut it down the middle and have the kitchen on one side and the bedrooms on the other. So things that are not susceptible of being split are going to have to be settled judicially or contractually. And more often than not, what happens is that you try to settle something judicially and the courts just order it to be sold. Just sell it and split the proceeds. It's the easiest way to do it. All right, so we're going to stop right there. We're going to come back on Tuesday with Chapter 9, Servitudes. I think I'm going to tell them about the test thing tonight. All right, so what happens is that we have been led to believe, all right, and I say led to believe because we haven't seen it yet, we've been led to believe that when you pass this test, you're getting a grade. You won't get a note in the mail that says pass, fail. They're going to say you passed and here's your grade, okay? So we would like to offer the person with the highest passing grade in this group that takes the test in June, okay? I'm talking to you. The person that takes the test in June, the highest passing grade, the night we swear you in, we're going to give you $500.
Oh, shoot.
All right, so you got a little extra incentive to study. One person with the highest passing grade in June, we're going to get one of those big blow-up checks to get the picture in the paper, you know?
We're gonna make a giant check.
You're gonna make a giant check,
Giant
just like
check.
you do in the paper. $500 for the highest passing grade for the test in June.
Alright, let me tell you a little bit about this
You have a
test
reason
that
to
I'm
take the test in
handing
June,
out.
now you do.
It is open book. This test is open book. Time it, please. Write on there how long it took you to take the test. That's what I need to know. The test that she's passing out right now. It's 50 questions. But it's open book. You ought to be able to whip right through it. But I want to know how long it took you.
Which has specific comment?
It's 1 through 7.
I'll have to do it this weekend.
You ought to be able to knock it out in 15 minutes.
Yeah, right.